Hello and welcome. Today we're diving deep into a crucial topic in Philippine remedial law, Rule 77 of the Rules of Court. This rule governs the allowance of wills that have already been proven and allowed in a foreign country and the subsequent administration of the estate in the Philippines. By the end of this session, you will be able to: first, understand the concept of re-probate or ancillary probate. Second, identify the key requirements and procedures for allowing a foreign will in the Philippines. And third, explain how the estate is administered once the foreign will is allowed. This is a high-yield topic for the bar exam, so let's break it down section by section, with scenarios, tips, and even a sample question. Let's begin with the foundation of this rule, Section 1. Section 1 states that wills proved and allowed in a foreign country, according to the laws of that country, may be allowed, filed, and recorded by the proper court of first instance in the Philippines. This is the core principle of re-probate or ancillary probate. It means that a will that has already been validated in another country can be recognized and given legal effect here in the Philippines. The purpose is to administer the portion of the deceased's estate that is located in the Philippines. It's a way to ensure that the testator's wishes, as expressed in their foreign will, are respected for their Philippine assets. Think of it this way: the foreign probate establishes the validity of the will. The Philippine reprobate simply gives that foreign judgment the force of law in our jurisdiction, but only for the assets here. This is a matter of comity, which is the principle of mutual respect between the courts of different jurisdictions. We recognize the foreign court's finding that the will is valid. Now, let's consider a scenario. Imagine a Filipino citizen, Mr. Santos, who lived in California for 30 years. He owned a house in Manila and a bank account in Makati. He executed a will in California, which was duly proven and allowed by a California court. When he passes away, his family wants to administer his Philippine assets. Under Section 1, they can file a petition in the Philippines to have that California will allowed here. This is the process of reprobate. A common misconception is that the Philippine court will re-examine the will's validity from scratch. That's not the case. The foreign probate is conclusive as to the will's due execution and the testator's testamentary capacity. The Philippine court's role is limited to determining if the foreign court had jurisdiction, if the will was proven according to the foreign law, and if the foreign judgment is authentic. It's not a full-blown probate trial. So, to recap, Section 1 allows us to recognize a foreign will to administer Philippine assets, based on the principle of comity, and the Philippine court's review is limited to procedural matters, not the will's intrinsic validity. Next, let's move to Section 2, which outlines the procedural requirements for initiating this process. Section 2 details the notice of hearing for allowance. It states that when a duly authenticated copy of the foreign will and its allowance decree are filed with a petition, the court must fix a time and place for a hearing and give notice as if it were an original will. This section is all about due process. Before the court can act, everyone who might be affected must be given a chance to be heard. The key requirements here are: first, a petition for allowance must be filed. Second, it must be accompanied by a copy of the foreign will and the order or decree of its allowance. And third, both documents must be duly authenticated. Let's break down. Duly authenticated. This means the documents must be certified by the proper foreign official and then authenticated by a Philippine consular officer in that foreign country. This process is often called apostille or red ribbon authentication. Without proper authentication, the documents are mere scraps of paper and have no legal effect in the Philippines. This is a common pitfall for bar examinees. Who can file this petition? The rule says the executor or other person interested. This includes heirs, legatees, devisees, or even creditors of the estate. The court must then fix a hearing and give notice. The notice requirements are the same as for an original will: publication in a newspaper of general circulation, and personal notice to known heirs, legatees, and devisees. Let's go back to our Mr. Santos scenario. His son, Juan, wants to administer the estate. Juan must file a petition with the regional trial court in Manila, where the house is located. He must attach a copy of his father's California will and the California court's order allowing it. Both documents must have the red ribbon authentication from the Philippine consulate in Los Angeles. The court will then publish a notice in a newspaper and send personal notices to Mr. Santos's other children. This ensures everyone has a chance to object, for example, if they believe the authentication is fake or the foreign court lacked jurisdiction. A key takeaway here is that the authentication of the foreign documents is not a mere formality. It's a jurisdictional requirement. The court cannot proceed without it. Now let's discuss what happens after the hearing, as outlined in Section 3. Section 3 describes the effect of the will's allowance. If the court finds that the will should be allowed, it will issue a certificate of allowance, signed by the judge and attested by the court seal. A copy of the will is attached, and the entire document is filed and recorded. The crucial part is this: the will shall have the same effect as if it were originally proven and allowed in that court. This is the moment of truth. Once the court issues that certificate, the foreign will is no longer just a foreign document. It's now a valid Philippine will for all intents and purposes, but only for the assets located here. The effect is that the will becomes the law of the case for the Philippine estate. The court will now proceed to administer the estate according to the terms of that will. Let's consider a scenario. Suppose Mr. Santos's will left his Manila house to his daughter, Maria, and his Makati bank account to his son, Juan. After the re-probate, the Philippine court will issue an order distributing the house to Maria and the bank account to Juan, exactly as the will dictates. The court cannot change the terms of the will. Its job is to enforce it. This is a key difference from an original probate, where the court might have to interpret ambiguous provisions. In re-probate, the foreign court has already done that work. A common mistake is to think that the Philippine court can apply Philippine law to determine the validity of the will's provisions. This is incorrect. The validity of the will's provisions is determined by the law of the country where the will was executed, as established by the foreign probate. The Philippine court's role is to ensure the will is executed according to its terms, not to re-evaluate those terms under Philippine law. This is another application of the principle of comity. So, to summarize, Section 3 transforms the foreign will into a domestic one for the purpose of administering Philippine assets, and the court's duty is to enforce its terms as established by the foreign probate. Finally, let's examine Section 4, which deals with the administration of the estate. Section 4 explains how the estate is administered. Once the will is allowed, the court grants letters testamentary, or letters of administration, with the will annexed. These letters extend to all the testator's estate in the Philippines. After paying debts and expenses, the estate is disposed of according to the will. Any residue, if the will doesn't cover it, is disposed of by law for estates of non-inhabitants. This section clarifies the scope and process of the administration. The letters testamentary or of administration give the executor or administrator the legal authority to manage the Philippine assets. The administration follows a clear hierarchy. First, pay all just debts and expenses of administration. Second, distribute the remaining assets according to the will. Third, if there's any residue not covered by the will, it's distributed according to Philippine law on intestate succession for non-residents. Let's consider a scenario. Mr. Santos's will was allowed. The court grants letters testamentary to his son, Juan. Juan's first task is to pay the real estate taxes on the Manila house and the lawyer's fees for the re-probate. After these are paid, he distributes the house to Maria and the bank account to himself, as per the will. Now what if Mr. Santos had a small piece of land in Palawan that he forgot to include in his will? This would be a residue. Since the will doesn't cover it, that land would be distributed according to Philippine intestate succession laws for non-residents. A common pitfall is to assume that the entire estate, including assets outside the Philippines, is subject to this administration. This is incorrect. The letters testamentary or of administration only extend to the estate of the testator in the Philippines. The foreign court retains jurisdiction over the assets in the foreign country. This is why it's called ancillary probate. It's secondary to the main probate in the testator's domicile. So Section 4 establishes the authority of the local court to administer the Philippine assets, following a clear order of priority: debts, then the will, then intestate law for any residue. Now, let's put it all together with a sample bar exam question. Here's the question. Mr. Smith, a British citizen, died in London, leaving a will that was duly proven and allowed by a British court. He owned a condominium unit in Makati. His executor, Mr. Jones, wants to sell the unit to pay for Mr. Smith's funeral expenses in London. Can Mr. Jones do this? Explain. Take a moment to think about how you would answer this, applying the principles we've just discussed. Let's break down the answer. The key here is the concept of ancillary probate. First, Mr. Jones cannot simply sell the unit. he must first have the British will reprobated in the Philippines. This is required by Rule 77, Section 1, to give the foreign will legal effect here. Second, to do this, he must file a petition with the proper Philippine court, attaching a duly authenticated copy of the British will and the order of allowance, as per Section 2. Third, once the will is allowed under Section 3, the court will grant letters testamentary to Mr. Jones, giving him the authority to administer the Philippine estate. Fourth, under Section 4, the administration extends to all the estate in the Philippines. The first priority is the payment of just debts and expenses of administration. Funeral expenses are considered a just debt. Therefore, after the will is reprobated and letters testamentary are issued, Mr. Jones can sell the Makati condominium unit, but only with the court's approval, to pay for Mr. Smith's funeral expenses. The key is that he must go through the Philippine reprobate process first. To help you remember the key steps of Rule 77, here's an acrostic. Let's use the word probate. P stands for petition. You must file a petition for allowance. R stands for reprobate. This is the process of allowing a foreign will. O stands for order. You need the foreign court's order of allowance. B stands for authenticated. Both the will and the order must be duly authenticated. A stands for administration. The court will grant letters for administration of the Philippine estate. T stands for testamentary. The letters granted are letters testamentary or of administration, with the will annexed. And E stands for effect. The allowed will has the same effect as if originally proven here. So remember probate, petition, reprobate, order, authenticated, administration, testamentary, effect. This can be a useful tool for recall during the exam. Finally, let's conclude with some essential bar tips for Rule 77. First, always remember the purpose of reprobate. It's to administer the Philippine estate. It's not to relitigate the will's validity. Second, authentication is non-negotiable. A foreign will or order without proper authentication is inadmissible. This is a common trap in bar questions. Third, the Philippine court's review is limited. It only checks for jurisdiction, due execution under foreign law, and authenticity. It does not apply Philippine law to the will's intrinsic validity. Fourth, the administration is limited to Philippine assets. The letters testamentary or of administration do not give authority over assets in the foreign country. And fifth, always follow the hierarchy of administration. Debts first, then the will, then intestate law for any residue. This order is crucial. By keeping these 5 tips in mind, you'll be well equipped to tackle any bar question on Rule 77. Today, we've taken a deep dive into Rule 77, covering its purpose, requirements, effects, and administration. We've seen how it allows us to respect foreign judgments while ensuring due process and proper administration of Philippine assets. Thank you for joining me.